Commonwealth's motion to prohibit reference to any pending internal affairs investigations or unfounded allegations. And I did just, I don't know why, I know you filed it previously, Ms. Little, but I just today had the opportunity to read your supplemental memo in opposition. Okay, so, all right, so this is twofold. So I'll hear the Commonwealth regarding Trooper Proctor and also regarding Sergeant Lank.
Sure. Your Honor, with regard to, I think the recent sort of progeny of cases between McFarland and Graham are sort of entirely instructive. I would submit as far as this particular area is concerned. So when it comes to Sergeant Lank, you're talking about a civil case with no judgment. There was no finding. There was no trial. So I think Graham and McFarland are pretty clear that that is not conduct that can be used in a criminal case to impeach a witness.
Why can't it be used regarding, I think what separates this in some respects from those cases, even though there's no finding, is just like the pure bias part of it, right? If there's bias in favor of the Alberts, which is what the defendants say their defense is among the possible third-party culprits, why can't they cross-examine on that?
Well, the information that I've seen, I don't think specifically lends to a defense of the Alberts. I think if it lends to anything, it lends to Sergeant Lank being involved in some sort of altercation himself, and whatever extent there's any veracity to whatever is alleged by the other parties to have occurred. Firstly. Secondly, I don't even believe, again, I think we're going to, one Albert equals the entire Albert family kind of thing. And I don't think that any of the Alberts that they point to, or at least that Mr. Yannetti got up and spoke about being potential third-party culprit targets, were even present, involved, or had anything to do with this prior incident. So whether or not Sergeant Lank knows or was 20 some odd years ago friendly with one member of the Albert family, or even two, if they're not any people that were at the residence on Fairview Road that night, that were present there in the morning when he arrived, pursuant to a call from a sergeant on scene to investigate, or anything of that like, I don't see how it's relevant to that form of questioning or impeachment. Particularly where it's an unsustained finding and there's nothing, concrete as to what transpired.
Okay, I guess my question was simply because something might not fit squarely in McFarland and Graham. If it's admissible for other purposes, then it can come in. Right. So who's arguing this part? We'll take these in two parts. So we'll do the Trooper Proctor part afterwards. But Ms. Little, I did say I'd give you the opportunity to argue those two cases, but if you want to, you can, but I'm more focused on the bias or motive part.
I'll just briefly address Graham and McFarland, because I do think it's very important that we make clear that both of those cases are completely an opposite to the issue that's before this court, which is admissibility at trial. McFarland and Graham both deal with whether the Commonwealth has an obligation to turn over certain discovery. That's not where we are right now, right? We filed the appropriate motion to receive discovery. We obtained information about an IA investigation. We obviously—
let's focus on Lank first.
Sure.
Okay. So, I agree with you. They're discovery cases. They're not admissibility cases.
Okay. So that issue aside, Lank has— he's one of the first responders, obviously, who went to 34 Fairview on the morning of January 29th. He's the first person to enter the Albert residence that morning. And he has a long-standing relationship with the Albert family, which is brought in by this sort of prior lawsuit that we brought to the court's attention.
The Albert family appears to be huge, right? Well, or very extended family.
Well, I'm getting there. So the altercation that Lank was involved in was after he deputized himself to involve himself in a fight that Chris Albert had been in. Chris Albert is one of the Commonwealth's witnesses in this case. He is Brian Albert's brother. He was with them all that night on the 28th. His son, Colin Albert, as you know, is a third-party culprit. So this is not some tangential family member. This is
Who would you intend to get, if I allow this, and we really need to see how things develop beforehand. So, Mr. Yannetti, I can tell you right now, I'm not going to allow you to open on this because I need to see how the evidence comes in.
It's not part of my opening.
Okay. Who would you intend? I see you have the Lopolito brothers on the witness list. I think that goes far further than I would allow. But who do you intend to get the testimony in through, and how?
through Sergeant Lank himself. I think we
Okay.
need to be afforded the ability to cross-examine him. Once that's done, we may need the
If he
local
denies it, and we'll
Exactly.
figure that out.
But I think the first step is allowing us to inquire as to his relationships and the connection that he has to the family and this incident that occurred.
so you can certainly inquire as to his relationship with the family. It's the incident. I need to see again, just reading of everything that I've read, Sergeant Lank doesn't have it. His testimony isn't as lengthy as other witnesses, right?
I don't think that that's necessarily true, Your Honor, as far as our
Mr. Lally said,
cross-examination.
okay, but for his direct is not as lengthy as other witnesses.
I think that's fair to say.
Yeah. So, all right. So go ahead. So through him, through Chris Albert.
Through him, potentially through Chris Albert as well, Your Honor.
Okay. All right. So, Mr. Yannetti's not going to open on this, and he said he wasn't planning on it anyway. So
No, Your Honor.
let's see how the evidence develops. It may be that we have a voir dire of Sergeant Lank and Chris Albert beforehand. Okay. So, I'm not going to take any action on this right now,
Okay.
but I'm not denying it as the Commonwealth's requesting me to do.
Thank you, Your
So
Honor.
we'll see where we go with this. Okay. All right. So now let's deal with the Trooper Proctor part.
So, Trooper Proctor, Your Honor, in regard to NEI investigation, which we have not received any material in regard to other than its existence. And I want to be clear on that because I think counsel might be a little confused by some material that we provided to them. So there were some interviews in regard to any sort of areas of potential bias with regard to Trooper Proctor and certain members of the Albert family. That was something that we did. So we had asked a couple of captains from the state police who are completely divorced from the investigation and completely divorced from our office, conducting interviews with regard to Trooper Proctor and a few of the other civilian witnesses.
Okay.
In
How
relation to
recently? I mean, it's all recent. When was that?
that was, I think, all discovery related to that was provided to counsel the week prior to trial.
Okay.
But they were done sort of in the weeks leading up to that.
Is that part complete?
Yes.
Okay.
So as far as the IA investigation goes, just the mere fact that there is an IA investigation, the Commonwealth would submit is not an appropriate area for cross-examination, and particularly when it's an open investigation, there are no findings and falls squarely within McFarland and Graham. And I understand what the court's comments before about, them being primarily discovery cases, and I would agree with that. But they also go to discovery cases as far as so if something can't be ordered to be provided in the course of discovery, then it's, I would submit inferentially inadmissible. So what I'm suggesting with this motion, what I'm arguing in this motion is that whereas there is no findings of liability, there's no findings of any wrongdoing or anything of that ilk, just sort of putting out there that there's an open IA investigation without anything more because nothing else exists at this point.
Why wouldn't it go to his bias and his motive? If he's under investigation, why wouldn't he have the motive to testify favorably, or why doesn't it go to that? Maybe not the fact that it's IAD, but just there's an ongoing investigation that he's aware of, that he's involved. And I don't know if his job depends on it. I don't know that. Maybe there's not enough to know. But why isn't that motive and bias on his part? Do you think that's prohibited by Graham and McFarland?
I do, and just for that specific, because essentially what it allows a defendant to do is to pursue a line of questioning that they have no idea what that line of questioning is or what it will eventually be. And it could eventually turn into nothing. And to allow that sort of imprimatur of the court to allow that sort of questioning into an area that is completely unsettled and completely there's no evidence to substantiate other than the fact that it exists without any sort of finding, without any sort of evidence to support it. I mean, we don't have any evidence as far as what that is or that it even pertains to this case. So with regard to all of that, I understand, that outside of McFarland and outside of Graham, that there are other avenues, as the court was alluding to, as far as motive, as far as bias, as far as things of that nature. But when it's just so scant as far as what that is versus sort of the connotation behind those questions, I just think it's unfair to the Commonwealth. It's unfair to the witness to be put in that position when there's really no information available.
All right. What do you say, Ms. Little?
Your Honor, I think that ADA Lally's representation that we don't know what this investigation is about is disingenuous, to say the least.
Why so? Why? Is there
Reason
something in
is-
the, hold on, is it something in the information that you've received
Yes, Your Honor.
from
and-
Mr. Lally?
Yes, Your Honor.
All right. So can I get a copy of that?
Yes, Your Honor.
Okay.
So, as the court knows, first of all, Graham and McFarland deal with the Commonwealth's mandatory discovery obligations, right? Those courts also very specifically state that there's mechanisms outside of those mandatory discovery obligations for defendants to obtain information that's relevant and admissible at trial. That's why we filed a Rule 17 motion requesting these disciplinary records, and that's why that was granted.
It was granted because the Commonwealth did not object.
So regardless, we've obtained those records, and the cases that Mr. Lally continues to cite do not stand for the proposition that that's the only mechanism by which information can be produced at trial. Those are discovery cases. They are not admissibility cases. Pursuant to that request, we have received information discussing the IA investigation at which Trooper Proctor is being questioned specifically about this case. This is not an instance where we're questioning whether or not there's a basis for an IA investigation. It's clear this investigation was predicated on the materials that were produced to the Commonwealth by the federal authorities in this case.
And initiated by the Commonwealth. The IID investigation was initiated by the DA's office, correct?
Well, as far, and just to correct what I certainly didn't mean to impute that this case had absolutely no bearing or there was no
I
basis for
didn't
it.
think you did.
But what I was saying with that is we don't know what the full extent of that is. But as far as what counsel is, what the court's question as far as the IED, it was something that our office had spoken to. We felt we had a duty to disclose to State Police Legal Counsel, and then they refer it to the IA, and that's how that investigation began. As it pertains to what counsel is talking about, that has nothing to do with IA. So the materials that the Commonwealth has provided, that was completely separate investigation initiated by the District Attorney's Office. in
Okay.
relation to that.
Okay.
The IA investigation came on the heels of this information being produced to the Commonwealth. This is not a situation in which we're really questioning what the basis of that investigation is. The Commonwealth has in its possession numerous materials that suggest there has been significant misconduct on the part of Trooper Proctor. That will come out at trial.
How?
However,
How?
through cross-examination.
What if they don't call Trooper Proctor?
We will call Trooper Proctor.
To impeach him?
Yes.
All right, so be prepared to argue that. I don't know. He's on the witness list. He's the first person on the witness list. They're probably calling him. I'm just
He's the lead detective
hypothetically
in this
throwing it out
case.
there.
He's conducted every single step of this investigation.
With others, right?
Excuse me?
With others?
Sometimes, but he is the primary investigator in this case. And I think it's very, very important for the court, and I think you noted correctly, that bias and motive are absolutely critical to Ms. Reed's right to defend herself at trial. We have to be able to explore those issues. And in order for Trooper Proctor to testify, he has a motivation to testify in a certain way to avoid liability in this pending IA investigation. So I think it's unfair to tie our hands behind our back and not be able to question him about this, because it directly drives his bias and motive in this case and gives him reason to testify in a certain way, knowing that he could face career consequences if he doesn't.
Do you intend to try and open on this, Ms. Giannetti? Because I need more information.
I'm not going to mention the IA investigation in my opening
Okay.
statement.
All right, so Mr. Lally, if you can get me that information that you mentioned that you
Sure.
had sent to council, I'll take a look at that. It may well be the fact that there's an investigation without what the nature of the investigation is, but that there's an important investigation, and if you can show me in advance that his job may depend on it, things of that nature, there may be cleaner ways to allow this testimony in. So, all right, so we need a little time. I need to read those materials.
Sure. And,
Okay.
and for the court's edification, I don't anticipate, he's sort of towards the middle, I would say.
Okay. All right, good. And the more fully the records developed and the easier to rule on some of these motions. I just want to give you all some idea so you know how to prepare for the next 2 weeks. So, all right. So not in your openings on either one of these, Ms. Giannetti, but you agree to that. So this is still under advisement. It may be certainly with Lank or Sergeant Lank of voir dire of Sergeant Lank and of voir dire of Chris Albert. We'll see how the evidence develops, and I'll read more about the information that the Commonwealth was provided. So 318, also it's 28 bolded from the Commonwealth.